Hello and welcome to this month's episode of The Legal Scoop. I'm Brendan Shannon, an associate attorney here at LOMAD, and this is our video series where we talk about recent decisions from the Third Department as well as the Court of Appeals. We've got a fun one this month, which is the Ramales v. Frank and Nino Pizza Corp case, which involves the question of whether claimant's intoxication was the sole cause of the accident and the sustained injuries. If you're not familiar with this provision of the law, Section 10.1 of the Workers' Comp Law provides that basically an accident is not compensable if intoxication due to alcohol was the sole cause of the accident. Now, it's a very heavy burden for the carrier or the self-insured employer to overcome in proving that the claimant's intoxication was the sole cause of the accident. Now, notice I emphasize sole cause. If intoxication is a contributing factor, that's not enough to overcome the burden of compensability, or of proving that it's not compensable. So in this case, the claimant was working at a pizzeria and he fell down the stairs while moving a pot of hot sauce to the basement, and he sustained burns over 40% of his body. He went to the hospital after this and was found to have a BAC of 0.28, which is 3.5 times the legal limit. So he was heavily intoxicated, and the accident just, the injuries resulted from a fall. The issue here was that the claimant testified that he was going down the steps one at a time, but that the weight and balance of the large pot caused him to fall. And the carrier produced a witness who provided hearsay statements from staff who stated that he was having difficulty walking and that he was told at least 20 times not to carry that pot of sauce down to the basement. However, the board discredited that testimony as hearsay. Now, hearsay is admissible in comp, but it can speak to the weight that the board will give it. And in this case, they didn't give it a lot of weight because it was hearsay. So ultimately, the court, as it will always do when dealing with credibility assessments by the board, deferred to the board's decision to not accord a lot of weight to the hearsay testimony and to instead credit the claimant's testimony and then establish the claim. Basically, the court concluded that the carrier did not overcome its heavy burden of demonstrating that the claimant's intoxication was the sole exclusive cause of the accident. I think what's notable about this one is it's a good example of why you want to work up your controverted cases from day one in conjunction with defense counsel to make sure that the best possible witness or witnesses are being produced, that any documentary evidence to support your defenses are produced, well in advance of the deadline for the pre-hearing conference. Because here, the witness that was produced, I'm sure, did a fine job testifying, but he didn't have the personal knowledge that other employees clearly would have, and that potentially could have bolstered the carrier's argument that the claimant's injuries resulted exclusively from his intoxication, because the 0.28 BAC is very, very high and would likely result in impaired walking and balance, and testimony that he was falling and stumbling, and from witnesses who directly saw this, and that he was told not to go down the stairs could have given a different result here. And it's a good example of why bad facts can sometimes make bad law, because here the wrong witness was produced, and now we got a bad decision from the Third Department where they're finding that even a claimant who has a blood alcohol level 3.5 times above the legal limit didn't fall exclusively because of his intoxication. So interesting case, and just one to be aware of. And again, it just reminds us of all the work that has to go into preparing contrary claims. We will be back next month with another decision from the third department, or who knows, maybe the Court of Appeals. If you like our video series here at LOMAD, please subscribe below. And again, we will see you next month.